I will hand this up to Your Worship because we only have one copy. My learned friends already have it. On the 7th of January 2022, my attorney, Mr. Godla, wrote a letter to Mr. Heather Bloom, who is the colleague of my learned friend who just spoke, making it clear once again that today will be about the bail application, and even quoting, firstly from Section 35 of the Constitution, that says everyone who is arrested for allegedly committing an offense has the right at the first court appearance after being arrested to be charged or to be informed of the reason for the detention, to continue or to be released. And the rest of the section also deals with the rights of an accused person. And we also quoted in that section 56A1, which is the one that talks about the 7 days. I quoted it earlier, so I'm not going to read it. I beg you to hand up a copy of this.
Ewe, ngokucacile ityala ke lamiswa namhlanje limiselwa intobana kwenzeke isikamangalela. Loo nto ke funeka ijongiwe ngokomgaqo-siseko okanye ngokoluhlu oluthethwa kumatyala kulomthetho ukuthi umangalela kunalo ilungelo lokuba makake makaqululwe ngaphandle kukho isizathu ke ezibekwe phambi kwenkundla ke ukuba kutheni into funeke igcinwe.
Thank you, Your Worship. And therefore, Your Worship, the position, again, I want to repeat what I said in the early morning. The position is very, very clear that the state is, or at least ought to be prepared, because irrespective of all these pointers that I've given to the record, to the submission of those documents, and to the letter, in any event, as Your Worship knows very well, an accused person is entitled to be released on bail or to have a bail application held at any stage, even before that first appearance, even at night, even on a Sunday, if the situation allows. So the application ought, if we are prepared, despite the fact that we are ambushed with a Schedule 6 certificate this morning, if we are prepared to go ahead, then that is the position of the accused. But more importantly, Your Worship, now this matter has been further complicated by the Section 78 / Section 79 issue. And the position of Mr. Mafe is the following. He is of the view, Your Worship, and he asked us to communicate this directly, that after today, he should no longer be in the custody of the state. And he should no longer be in the custody of the police. And all the things that have happened to him in the last few days, which I don't want to go into, some of them will feature later in the trial itself, should no longer continue. I must just say, Your Worship, that he gave us a long account. My learned junior and my attorney will testify to that. But I would not be able to articulate the full extent of what he says. But one thing that he wants this court and everyone to know, he says that if his bail application does not proceed and he is not released from custody, as from this moment, he will embark on a hunger strike, and he says that will be to whatever consequences, but he will do that. But I want to make it clear that he says that he's not doing that in order to place any particular pressure on the state, but he wants to, his reason he articulated, I had to scribble it down so that I don't misrepresent it. He says he does not understand why the government, which was not able to feed him when he was poor outside and fending for himself, now is so keen to feed him for a further period of time. And he is very aggrieved by this, and all the strange attributes of what has happened in the last few days, which I've already outlined to the court, point to him that he is being victimized and targeted, particularly because he is poor. And therefore, he is not prepared to take any food offered by the government under such conditions. He said a lot of things, but I just thought that I should put that matter in its proper context. But he also said I should communicate to your worship that there is nothing wrong with him, so none of what has been said here can justify the further abuse of his liberty by not granting him bail. And therefore, as he says, he's not prepared to trade his liberty for food. Your Worship, your Worship's permission, can I just confirm?
Yes, you can.
As the copies, Your Worship, thank you. I've agreed with Mr. Mafe that other issues he might address in a different forum. But his ultimate position is that he will leave the matter in the hands of the court, but he would like for there to be a bail application on his behalf, as has been clearly communicated, and as everyone has clearly been preparing for such an application. We do understand that our learned colleagues wish to oppose such an application. Our overall submission is that irrespective of what happens with the so-called Section 78-79 issue, the accused person as an individual who is a bearer of his own rights and human dignity is entitled to bail and is entitled. There's no rule that says that even an accused, as Your Worship knows, even if in the middle of a trial, if an accused person seems to be unstable, the Section 78(2) that was read out by my learned friend, then at that stage, it would not follow that he must then be re-incarcerated. As Your Worship, in the first case that happened this morning, I know that Your Worship mistook the person to be on bail, but that is an indication of the fact that even a person on bail could still be referred to an observation. So I don't want us to conflate those two issues, Your Worship. The issue of the psychiatric observation stands on one side, but irrespective of that, the position of Mr. Mafe is that he should be admitted to bail. Or rather, I'm sorry, ma'am, or rather be given an opportunity to move his bail application.
Any response from the state?
Not every person facing 3, 5, and 6 charges is entitled to bail. They usually are entitled to be heard to bring a bail application. It doesn't mean that they're going to get bail. In fact, that is under normal circumstances. These are not normal circumstances. However, it was also report that the state is to blame for not providing the defense with a copy of the charge sheet. Let me put that in perspective. Last week Tuesday, we were all here together, and there was a copy of the charge sheet going around. Our liaison officer made screenshots of the various annexes to the charge sheet. Mr. Boydell was more concerned with going outside the building to the media, making the slightest interest in having a copy of the charge sheet. I would happily give him a copy of the charge sheet and gone to the top of the court, made a photocopy of the J13, the annexes, and believe the words of Bishop wrote about the proceedings. He couldn't care. On Friday afternoon, after 7 o'clock, he sent an email to my colleague, which we couldn't open due to the fact that our computer said it contained malware. Mr. Boydell was informed of that. I made a phone call to him, I spoke with him, and I forwarded to him by WhatsApp the annexes to the charge, which I thought what he wanted. I thought maybe he wanted to consult over the weekend with his client, and at least I could provide him with the 5 annexes pertaining to the various charges of the charge. I didn't realize what he actually wanted was what your worship report pertaining to the reasons for the postponement, etc., etc. Nothing prevented Mr. Boydell from going to the clerk of the court on Monday and getting a charge for himself. I don't know why he assumed the advocates for the state would actually have a hard copy in opposition, which we didn't have. That is the history of the matter. We didn't not provide him with a copy because he didn't want to do so. He didn't have a copy of the J15 in annexes and the viewership have recorded of the proceedings of the matter. The matter was not postponed for the finalisation of the charge sheet. There was nothing to prevent the charge from adding count number 6 this morning. There might have been a surprise with the defence, and I agree to that, but we only finalised the charge sheet yesterday after having watched video footage of downloaded information on top. Advocate Bell only signed the Schedule 5 and 6 certificate. I don't know whether the court has got a copy of that as yet, because it was an issue on the previous occasion, but it wasn't fact Schedule 5 application. The court has not a copy of it.
I have a side of it during our discussion in chambers. However, I will need for the charge sheet, yes.
5 and 6 application. That does not, in fact, retract the fact that there is evidence before the court by means of a statement of the district surgeon who is a qualified medical practitioner who says the accused should be referred, and the court is obliged, compelled. The court has no discretion in referring the accused. That makes it clear. The court must refer the accused for 30 days. I'm aware the article. The court has to. There's a basis for this on the report by means of a statement by a document submitted by the district surgeon. That is why the state is adamant that the accused must be referred. And the state cannot be blackmailed or held ransom by the accused statement that he is going to go on a magistrate. It is also not a given that the accused will be granted bail. If, for example, he doesn't get bail, is he still going to proceed with being on a magistrate until he dies? How can I guess? How can the court guess? We certainly cannot be held ransom by the accused allegations if he can go on a magistrate. The state is adamant that the accused must be referred for 30 days observation. It's going to be prioritised. We can do our utmost to see this. Taking up the British Department as soon as possible. We cannot do more than that. As the business.
Thank you, Worship. I won't say much in reply,
Yes.
except firstly to indicate that we take very great exception to the personal attacks against my attorney, Mr. Kotla. The facts are as we have put to the court, and we were not furnished with a hard copy of the charge sheet or any other relevant document until this morning. It is indeed so that my learned friend, Ms. Boise, had sent some crypt WhatsApp, which Mr. Kotla did acknowledge, but he still insisted. In fact, he still wrote the letter that you have, Your Worship, where he required a copy of the charge sheet. But what is not in dispute is the fact that the new charge, the so-called terrorism charge, was only added this morning. And what is not in dispute is the fact that the certificate from the acting DPP was only handed this morning. And what is also not in dispute is the fact that the document of the so-called psychiatric evidence was only handed in this morning. That is the position, Your Worship. And I do not have to tell Your Worship knows it instinctively, that what we're dealing with here is the liberty of a person. It's not me, it's not Your Worship, it's not my learned friend. It is the constitution of this country that says that a person in this position is presumed to be innocent and entitled to his liberty. The mere fact that the onus in a particular set of circumstances lies on him does not change the constitutional fact that he ought to be released unless if there are so-called exceptional reasons. or rather that he should show exceptional circumstances for him to be released on bail, simply because we're dealing with Schedule 6. But that's not a matter about the rights of the person. That's a matter of procedure. And it is that opportunity that he seeks. He has not yet done a bail application where we can talk about owners. He simply wants an opportunity to do so. What will then happen in that? What will happen in the bail application itself? Who bears the owners on what scale is something that we're not even entering at this stage, but simply appealing for his right to apply for bail rather than applying for bail at this stage. And that distinction also we have to make conceptually. Is he entitled to apply for bail, for better or for worse? Whether the bail will be granted or not granted for whatever reason, psychiatry and otherwise, is another matter. But to deprive him for 10 days of an opportunity to place before a court of law reasons why there are exceptional circumstances that he should be released is the height, or it's a travesty of justice and the height of unfairness on the part of the state that had this information for such a long time. So we appeal to your lordships inner sense of justice to say that it cannot be that the intervention of this document that we were given this morning must now deprive Mr. Mafe of his opportunity to ask for bail until, I don't know, whatever happens in some hospital in months and months to come. That is patently unjust. If it was me or you or anybody or your worship or my learned friend, he would, or a relative of hers, she would understand that that is just, and she says that it's it might be a waste of time to do so because of the Section 78 issues. How can it be a waste of time to release somebody to his liberty? How can it be a waste of time? The waste of time is the one that of keeping somebody for an indeterminate period that we don't know. We don't know what the backlog is. A learned friend kindly says that although there's a backlog, they will try and get the matter to be prioritized. Well and good, but what does that mean? It might take months. Is it going to be a matter of months or how long? And all along, two things must happen. The person must remain in custody, and two, they might be found, as he says, to be actually no less sane than anybody else on the side of the court. And so that only then shall we say, oh well, maybe he should have been released 10 months ago. If that is not abuse and a manner of introducing the indefinite detention of this gentleman, then nothing ever will qualify, Your Worship. And I must emphasize that all we want is for Your Worship to give us an opportunity to apply for bail. And of course, one of the factors Your Worship will take into account in that process will be this fact that there is a Section 78 certificate, but the two things must not be conflated.
kuba kaloku umntu xa evela phambi kwale nkundla funeke esenzile isicelo sakhe sebhili. Kubonakalisa uba inkundla yenza ukulungisa nakubani na ovela phambi kwale nkundla. Esithi nalapho xa umangalelwa evele enkundleni isengamarhaneleko lokuba ngaba kukuphazamiseko engqondweni. Umntu uye avele phambi kwenkundla qoqoqo ethubeni kuye kuvela hayi uphazamisekile. Kutheni ke kungenziwa njalo umangalelwa? Umangalelwa yena ngokwakhe uthi akho ngxaki yena ngalicala lakhe. Ngoba usanele ke sicela enkundleni ukuba ngaba isamkele isicelo sokuthi umangalelwa makasenze isicelo sakhe sebhili.
I'm very sorry, Worship. Just one little thing that I've been instructed to add, which is an extension of what I had said in the morning. The Worship must please take into account the fact that the same state that is saying that there's a possibility of mental incapacity is the same state that this morning has added charges against that very same person that they say might be incapacitated. And that's the first thing. The absurdity of that speaks for itself. But the second one is that one of the implications of that is that this matter, once it has now been escalated to a matter of dealing with terrorism, there's a likelihood of having to be referred to the High Court at a particular stage. All those, Your Worship will know in your own experience, all those are matters that will be a cause for some substantial delays between today and the actual trial, which will follow. And we would like Your Worship to take that into account. Again, not for the purpose of setting bail, but for the purposes of granting the opportunity, which might not come, because they have not said anything actually about the bail application. They've only told us about the observation.
Sithi ngicela ke ukongeza ke lokuba ngaba ke kwicala lamangalelwa apho kwicala zokutshutshiso lusithi kungenzeka into yoba ngaba umangalelwa uphazamisekile ngokuphelele kwasempilweni. Kuloo nto sijonge phinde kwabona bongeze esinye isimangalo. Sithetha ke ngomntu ubona abacingela into yoba ngaba uphazamiseke engqondweni. Kuthi nalapho zakhona ingxaki ezawuthi zenzeke emalanga etyala kuba ke kongezwe ityala elingelinye kumangalelwa lokuyikisa ngokundlobongela. Thetha ukuthi ke elo tyala ke lingathunyelwa ke kwinkundla ephakamileyo e-High Court. Leyo naleyo into funeka sijonge uba uyawubangela ubekho ulibaziseko oluninzi malanga ngeli tyala ukuthi umangalelwa yonke aqoqe imikhono. Loo nto izakubangela uba oko umangalelwa engaphakathi.
Can I conclude?
This is a most brief remarks on the worship. As I said before, there is no guarantee that the accused, if he brings a application on the Schedule 6 bail will be granted bail. Secondly, if he's not granted bail, he may very well stay in custody and go on under structure. Thirdly, if he is granted bail, at what stage are we going to determine whether the accused's accomplice members in the middle of the trial or no? If he's not accomplice members, he may never be tried. Fourthly, if he's an outpatient, he cannot be referred to Kaltenberg on the basis for 30 days observation if he's out on bail. But the Act doesn't provide for that. So the state says he should be referred to Kaltenberg now to determine whether he is competent, and if not, that is the end of the story. As the
Tshutshiseni uqala jonga into yoba ngaba akho siqinisekiso into yoba ngaba umangalelwa uzawufumana ibhodi wasenza isicelo sebheli wasenza asiyazi imiphumela loo nto. Nalapho into yoba ngaba umangalelwa abe ngaphandle uthi ayonto ilula into yoba ngaba ngaphandle xa ngokufunyaniswa into yoba umangalelwa uphazamiseke uba makabuyiselwe enkundleni ngaba yinto elula. Ngoku usamele umangalelwa makathunyelwe esibhedlele.
I will deal with the judgment today because the issues that has to be determined are not that complex. The first issue that has been brought forth is the question of the state whether can a date for bail application be arranged as requested by the state. But the most thorny issue that this court must decide is the application of Section 78 of the Criminal Procedure Act, which says that the court must or shall refer an accused person to a mental institution if there is a prima facie evidence that has been presented before it, that the accused must be observed and the report must be obtained to determine whether the accused will be fit to stand trial or not. Those are the two issues. The issue of the bail application, the accused will always have his right to bring bail application at any given time. But on the issue of committal to Falkenberg Hospital or mental institution, my hands are tied. I'm a creature of the statutes. Whatever I say is within the four corners of this book, which is the Criminal Procedure Act. When it says shall, it does not give me any discretion. Therefore, the court is making an order that the accused must be committed to an institution, taking into account the number of charges that has been placed against him, even though he is innocent, is presumed innocent. Those issues will be ventilated at a trial. But for now, based on the documentation submitted to this court by the state, which has not been rebutted by any other forms of expert evidence, the court is making that order that the accused be committed to a mental institution for the purpose of observation. That is an order. The defense is always entitled to bring bail application as at any times of the proceedings. And secondly, the evidence of an expert is only countered by other experts, which I'm not a medical doctor to dispute the document that was presented before me. That will mean the defense is also entitled to refer their client to their independent doctors. That is an order we can agree on the way forward, whether we still need to arrange a date for formal bail application in the light of this order, or
Your Worship, may I address the court in this regard? I have spoken with the chief psychiatrist this morning personally. She's Dr. Diakalashi. She suggested that we postpone the matter for 30 days, pending the availability of the bed in Falkenberg. She's also given her undertaking that she will prioritize this matter. There may become a bed available before the 30 days, in which case they will requisition the court, like Mr. Modak appeared this morning before this honourable court, and the accused will then be referred to Falkenberg. Maybe before the 30 days. In the meantime, it will be kept in Polsmoor, awaiting a bed as soon as one becomes available. So provisionally, I ask that the case be postponed until the 11th of February. The accused and kept in custody in Polsmoor. If it becomes available before that time, which we sincerely hope will be, then it will be taken to Polsmoor, and the worship will be asked to bring it. He will be referred to Falkenberg by Mr. Modak this morning, and he will be observed. It might not even be a full 30 days observation period, depending on how quick they can assess the accused and make a finding. In the meantime, I have laid out a formal situation to sign.
And then it's again, my brother wanted to
defense is the date in order.
Your pending the outcome of the court control, we may prioritize this case and fix the bail application as soon as the renewal results.
Is the date 9th of February or 11th?
11th of review is 30 days from today.
The case.
Thank you, Your Worship. Your Worship, well, let me just say this. We hear what Your Worship says in terms of the Section 78 issue.
Yes.
So I won't address that much further. But regarding the issue of bail, Your Worship, I have just one quick request. If I can confer with my learned friends and the accused in one.
Yes, certainly you can.
That's what it is.
The case is postponed until the 11th of February 2022 for observation.
Sorry, I can't hear you.
The case is postponed until the 11th of February for observation. The accused is in custody in the meantime, and you can indicate if we still wish to secure a date for bail application whilst
Yes.
the data are still available.
No,
Yeah.
thank you. I'm sorry.
Yeah.
I'm going to obtain a certificate from Magistrate that this matter be dealt with in the regional court if we proceed. So we will have to make arrangement for the regional court magistrate to make a date, a bail date available. Don't be caught by surprise, is what I'm thinking.
That has been communicated. I want
Yes.
to record it.
No, thank you. I appreciate that from my learned friend. Our position is as follows. The reason why I asked for time to confer with my learned friends was so that we could agree if, or at least we to attempt to agree that the bail application, as indicated, should be done as soon as possible. And by no later than the end of this week. Our learned friends have indicated that their office is closed, so they're not in a position to confirm the date suggested by us, which is Friday. So that's the one thing. As far as the accused is concerned, he has just confirmed that his position is that he says as of this minute, then he will embark on his action, and that I should communicate that. But that whole situation can be circumvented if we are able to have a bail application as soon as possible.
I hope the state will assist you to secure a date at the regional court as soon as possible.
As soon as possible, as court pleases.
I understand that we are liaised with the regional court vice president will be acting with the suppliers of the date and the magistrate manner.
Yes. It's no problem because you can communicate with Mr. Hola, and then Mr. Hola will communicate with
As
counsel.
it pleases the court.
That's your role. I'm not sure whether Mr. Bulan is here. Yes, we still have other men. We certainly have queues.
Sorry, she's still in
Sorry.
The court is adjourned, but will continue with the normal role of this court.